Welcome to our Lunch and Learn program today. My name is Jillian Bewick. I'm president of the board of directors of the Red River Valley Asperger Autism Network. We have several other board members here with us today. The Red River Valley Asperger Autism Network is a nonprofit organization whose mission is to educate about, advocate for, empower, and support persons on the autism spectrum and their families. We're privileged to have today our speaker, Susan Johnson-Drenth. She practices, her practice areas include elder law, estate planning, probate litigation, guardianships, and trust law, including special needs trusts for the disabled. She is the only certified elder law attorney in North Dakota and northwestern Minnesota. In addition to practicing law, she continues to hold licensure as a registered nurse in North Dakota. She is also a certified mediator specializing in contested probate and guardianship matters, having received her training at Northwestern University in Chicago. Sue gives frequent presentations on all areas of elder law and has written numerous articles on elder law topics for newspapers, magazines, and newsletters. She was named to the 2015 North Dakota Super Lawyers List in the area of estate planning. Sue is a native of Fargo, North Dakota. She and her husband, Dan Drenth, enjoy golfing, snowmobiling, and spending time at the lake with family. So, welcome and thank you.
Thank you. So, what I'm going to be speaking about today are special needs trusts and supplemental needs trusts, and why those are a good planning option for individuals that have a disability. Now, are any of you from the Minnesota side of the river? Okay, because there's a difference between North Dakota and Minnesota with the trust that I'm going to be speaking about. So where there are differences, I'll let you know. But before I dive into the slides, I'd like to give you a bit of an overview so that you understand how special needs trusts work. So as we're going through the materials, that you'll understand some of the nuances and it'll make more sense to you. So let's say, for example, that I was an individual with a disability, age 25, and I was on SSI, Supplemental Security Income, and I was getting medical assistance. And then all of a sudden I got an inheritance for $100,000. And that inheritance was made out to Susan. And that inheritance could have been coming from a will, or it could have been coming from a life insurance beneficiary form. But someone was very generous and decided to leave me $100,000. Well, when I'm on SSI and Medicaid, I'm only allowed to have $2,000 in assets or I lose those benefits. And now I find out I've got $100,000 coming to me. This is a very common type of situation that I see in my office at least once a week. And so what do? You put the brakes on before you have that $100,000 check sent to me, and you go talk to a lawyer about what can we do so that Susan can get the inheritance but still stay on her SSI and her medical assistance or Medicaid. And that would be setting up a special needs trust. So a special needs trust would be prepared, and there's certain ways that it has to be done, and we'll talk about that. But then that $100,000 would be put into the special needs trust. And someone would be the trustee in charge of that trust, and it could be my family, or it could be a bank with a trust company, but it's not going to be in my social security number, it's going to be in a separate bank account in the name of the trust. And once it's in that trust, it's irrevocable. Once I've decided to let it go in there, I can't change my mind and then take it out. And once it's in the special needs trust, then I have to tell Social Security Administration about it, and I've got to tell medical assistance about it. But they're fine with it, as long as the trust was written properly, as long as I'm not the one in charge of the trust, or my spouse, and as long as the trust is used properly. So then, when I need something from that trust, I call up the trustee. And there's things that I can get out of there and things that I can't get out of there. If I call up the trustee and say I'd like to buy a car, the trustee just can decide whether or not that's a reasonable thing for me and then buy me a car. And the trust can pay my car insurance. That's not a problem. If I call up the trustee and I say, I'd like a check for $800 a month, please, the trust can't distribute cash to me, or it decreases my SSI payment and increases my recipient liability or client share for my medical assistance. If I call up the trust and say, I'd like to go to a dentist that doesn't take medical assistance, can I send the bill to the trust? The trustee would say, no, the trust can't be used for medical and dental things. But once it's in this trust, as long as it's written properly, that I'm not the one in charge of it or my spouse, and that it's used for the correct things, then how much is in this trust is irrelevant, because medical assistance and SSI will count the trust as a big fat donut. It's worth nothing, and it does not count towards my $2,000 asset limit. Then, when I pass away, since this was money coming to me, it will be what's called a payback trust. When I die, anything left in it will go to any state that provided medical assistance to me to repay the taxpayers for everything that they gave to me. And after the state is paid back, then I can list other beneficiaries to get what's left. If this was done the proper way, and instead of me inheriting $100,000, there was my parents set up a trust for me, a special needs trust, and that $100,000 went in there the correct way, I can still handle the special needs, or have the special needs trust for my lifetime, but then when I die, it doesn't go back to the state. It can go to other people. So that's just a quick overview of how all of these trusts work. So let's dive in. In Minnesota, the third-party supplemental needs trust, if a trust is created for me by my parents, my grandparents, my aunts, uncles, brothers, sisters, somebody other than me, it's called a third-party special needs trust in North Dakota, and in Minnesota it's called a supplemental. And a self-settled special needs trust is that example that I gave you. I came into $100,000, it just came out of the air with Susan's name on it, and I need to retain my eligibility. Nobody else set up the trust for me, but I need to do it now. That's called a self-settled special needs trust. There are also pooled trusts. Pooled trusts are through nonprofit companies like the ARC, LSS, Guardian and Protective Services out of Bismarck, where they manage and mass lots of trust funds for many individuals, but it's only for cash. It's not for interest in land or minerals, that type of thing. And so pooled trusts are an option sometimes for families that don't have a bank that they use, or not a family member to be the trustee. Or perhaps it's just a small amount in the trust. It's not going to be a tremendous amount, and it's just going to be going in and out, like $10,000 or something like that. Another possibility that I'm not going to be going into in depth today, but I just want to plant the seed of it, is going to be the ABLE Act. And that's achieving a better life experience. And Obama put that into law at the end of 2014. North Dakota passed the ABLE Act, as did Minnesota, in 2015. ABLE Act is going to allow an individual to put money aside into their own account without having to go through the legal expense of having a trust and a trustee done. But there's limits to it. You can only do $14,000 a year, and it can't exceed $100,000. And the state gets everything left in it when you die. Now, the reason I'm not ready to talk about it today is in North Dakota, it's not going to be in existence until the end of 2017 or the beginning of 2018, because the law in North Dakota for the ABLE Act last year was written incorrectly. And so it passed the legislature, and it's got improper wording, so they can't institute the ABLE Act in North Dakota until that's fixed, and we don't have a session in North Dakota until 2017. It's going to be implemented through the Bank of North Dakota. That will be the only vendor that I've heard of in North Dakota that will have the ABLE Act. So in late 17 and going into 2018, if you've got someone who's got $5,000 or $10,000 that they want to set aside, but they don't want to spend several $100s of that on a lawyer, the ABLE Act is going to be a way for an individual with a disability to just set aside their own money working with the Bank of North Dakota or through their guardian. Now, in Minnesota, the same law got passed in the summer of 2015, and the Minnesota Department of Human Services has signed a letter of intent that they will be instituting it, but it hasn't gone any further than that. There aren't any actual live ABLE accounts that you can use yet in Minnesota. And I've been told it will be available on the Minnesota Department of Human Services website as soon as it's up and going. But Minnesota is going to national meetings with other states to see how they're setting theirs up, and they said that when I called them yesterday that it's going to be 2017, but earlier that it will not be in 2016. So for those that haven't been involved with a trust before, a trust is a totally separate entity from the individual. And so when a special needs trust is set up, it does not and it cannot have the social security number of the disabled individual. It has to have a separate tax ID number for it. If it was under their social security number, it would count as their assets and count towards their eligibility. And so it has to have a separate number. If it generates enough income in any given year, it has to file a separate income tax return. And there's very specific rules for a trust. And special needs trusts can be as different as somebody's will or somebody's other legal papers. They're as different as the lawyers that draft them. And so just because you have a special needs trust and your friend has a special needs trust doesn't mean they're the same. You have to go into the documents and read the specifics. There's always three parties to a trust. There's the trustor, the trustee, and the beneficiaries. The trustor is who creates the trust. And with special needs trusts, as I mentioned, it can be parents, grandparents, it can be a guardian, it can be a conservator, and in some instances, it's the court. But whenever the trust is created, it's only ever got one trustor because the trust has to be irrevocable. Once it's written, you can't redo it and change your mind. The trustee is going to change over time. And so when you do a special needs trust, because it's irrevocable, you can't change it, you want to put all kinds of options. You might list yourself as first trustee if you're not the one who's the disabled beneficiary. And then in case you die, it's your husband, and in case your husband dies, it's your oldest son, and then it's his wife, and then it's somebody else. And then ultimately, you might put down a bank and trust company in case the disabled individual outlives everybody. So that you have all kinds of choices when you list your trustee. The beneficiaries are going to change also. The primary beneficiary of any special needs trust has to be the disabled individual. Now, since I'm the chair of the Elder Law section for the State Bar Association in North Dakota, I get a lot of referral cases to me that are kind of where the wheels fell off the bus. Something happened wrong. And at least once a year, I'll work on a trust where the attorney who did it meant really well, but did it wrong. And maybe the attorney represented mom, who set up a special needs trust for her daughter, who maybe has some cognitive impairment or some mental challenges, and is on disability, and her daughter has a child too. And so mom set up the special needs trust so her daughter, as well as her grandchild, can both use that trust together. Because she wants the whole family to use it. And the attorney thought that was a great idea. Special needs trusts can only be for the sole benefit of the disabled individual. And so mom can set up the trust for her child, but not to include her grandchild. The grandchild can get what's left when her daughter has died, but they can't share use of the trust while the daughter's living. Otherwise, Medicaid and Social Security will not allow that trust at all. So it has to be one trust per disabled individual. But once the daughter dies, there may be another beneficiary, which is the son. It could be other contingent beneficiaries like a charity. And with self-settled special needs trusts, it would be the state to repay for Medicaid received. So trustor is the one who creates it. Trustee is the one who's in charge of it. there's a very common discussion that I have with families when they're talking about who the trustee should be. They may have numerous children and one of the children has autism, for example, or Asperger's, or Downs, or some other issue with a disability. And the parents just assume, well, when mom and dad die, these 4 kids will just take care of their sibling. But these 4 kids have their own families and their own jobs, and they may live in different states. And so I have to play devil's advocate and challenge the parents a little bit. Okay, if you name this child who lives in Alaska and has his own business and family in Alaska, because he's the oldest to manage his brother's special needs trust, is he really going to have the time and ability to make sure that it's done correctly? Because I understand you want to treat your children fairly and go oldest to youngest, but is that going to be in the best interest of your child with a disability? Because if the wrong bill is paid and if this special needs trust isn't managed correctly, your child with a disability may lose medical assistance and SSI until that trust is completely depleted. And there is no, oops, I didn't understand, oops, I'm not a lawyer, because the state is constantly wanting to take those assets in the special needs trust and count them against your $2,000 asset limit, and you have to keep up that barrier by handling the trust correctly. If a trust company screws it up, they've got insurance to make it right. If your other children screw it up, they don't. And so it's a real important decision that you've got somebody, if you're going to name family, who ideally is local, who has the time, interest, and ability to be able to properly manage a special needs trust and continue to stay educated about it and the changing medical assistance rules and SSI. Has anybody ever had to fill out those forms before? Okay. They're not simple and they don't just take 5 minutes. And so that needs to be somebody who's got the time, interest, and ability. Otherwise, you should look at a trust company. So just generally with special needs trusts, they allow individuals with a disability to supplement their government assistance like medical assistance and SSI, and whatever's in that trust, whether it's $100 or $100 million, does not count towards their asset limit. So however much is in the trust is irrelevant. But the trust cannot be used for certain things. The SSI check that an individual gets, that's our federal government providing for an individual with a disability who cannot have gainful employment, and that SSI check is for food and shelter. It's for the groceries and for their rent. So you can't use the special needs trust to pay for groceries and rent, because if you use the special needs trust for those things, then your Social Security check, your SSI the next month will be reduced dollar for dollar. And so if we are working with an individual with a disability and they have a special needs trust and they say, well, can I have an extra $200 a month out of my trust to help pay so I can stay in a nicer apartment? Well, if we do that, then their $700 and some SSI check will be reduced by $200 the following month. So it just shot them in the foot. Instead, what the trustee will do is ask them, why isn't your SSI check paying for your rent? What bills are you paying that we can pay out of the trust so you have more free money available to pay your rent? And then may find out, well, we're paying a $100 cell phone bill. Well, the trust can pay that, send that to the trust company, or send that to whoever your trustee is. Well, what about my cable in my apartment and my internet? The trust can pay for those too, have those directly paid out of the trust. The bill can go straight to the trustee. And so by freeing up some of the other money that they're paying on bills, instead of giving them cash, it works out quite well. Then when somebody is receiving Medicaid in North Dakota, medical assistance in Minnesota, the trust cannot pay for medical or dental expenses. Because if you have a resource that's paying for medical and dental expenses, then medical assistance will say, you don't need us. And so when somebody's on medical assistance, then the trust needs to shut its door for paying any medical or dental expenses. that are otherwise covered by Medicaid. So if somebody needs a cavity filled, is that going to be covered by Medicaid? Yes. If they want their teeth whitened or cosmetic dentistry, is that going to be covered by Medicaid? No. And so cosmetic dentistry, if that was a reasonable thing for the beneficiary, even though it's dental work, could be paid by the trust as long as Medicaid doesn't have that type of coverage. So the best type of special needs trust, there's third party and there's self-settled. Third party is the best kind because when the disabled individual passes away, there's no state payback. But with a third party special needs trust, there's one important thing that's required, and that's advanced planning. So this can't be done after somebody dies. It can't be done after somebody's named as a beneficiary on life insurance and the insured passes away. Instead, it has to be done by the parents of the disabled individual, auntie, uncle, grandparents, whoever it might be, before they die. And so this is part of your estate planning. And it's set up by anybody but the disabled individual. Because does a parent or a grandparent or a sibling of an adult disabled beneficiary, do they owe them anything? Are they required to leave them an inheritance? No, it's by choice. They're being very generous. And so by setting up this third-party special needs trust, the government can't say who gets that. It's used for the disabled beneficiary, but the government can't take it when they die. You can say whoever it's going to go to after the disabled person passes away. But it has to be set up with anybody's assets but the disabled individuals. And so it can be used as a provision in your will, or it can be established during your lifetime for the benefit of a child or grandchild. In North Dakota, there's an interpretation that still stands. It's not black and white rules, but it's an understanding with the Department of Human Services that a parent cannot be the one who signs the trust for their underage 18 child. So when I'm working with parents of a disabled 2-year-old or 5-year-old or 10-year-old, we still do a third-party special needs trust, but I have to have their grandma, grandpa sign it or somebody else sign it. North Dakota says that parents shouldn't be signing those for kids under 18 because they have the duty to support their kids and there could be potential welfare fraud there. But it's just a way to get around it. But we still get it done. In Minnesota, it doesn't matter. Parents can sign it anytime. The alternative, the lesser of the two, is a self-settled special needs trust. These hold the assets of the disabled individual, and under federal law, it has to be set up by a parent, a grandparent, a legal guardian with full financial authority, or the court. The only time a disabled individual can set it up currently is with a pooled trust. And this is a lot of information, but I'll give you some examples. Many times I'm called by a personal injury or medical malpractice plaintiff's lawyer saying, we've been working on a case for a while and we've reached a settlement. And I've got a client that got hurt in a car accident. They now have a traumatic brain injury. They're no longer able to work. They're on Social Security and medical assistance, disability and medical assistance. And if they get this $500,000 check from the insurance company, they're going to lose their benefits. And Susan, I've heard you can help prevent that. At which point I insert myself into that litigation and I have the court create a self-settled special needs trust. Was this $500,000 coming from mom, dad, grandma, grandpa? No. This $500,000 and the right to collect it is owned by the disabled individual. So I don't have a choice. The only type of trust I can do is a self-settled special needs trust, or they can get the $500,000 in their name and lose their benefits. And so instead of the insurance company writing the check to the individual, they write it to the trustee of the trust. And then that trust can be used for special things for the lifetime of the disabled beneficiary. When that individual dies, the state will have a claim against whatever's left in that trust, but only to the extent the state paid for medical assistance plus interest. And there can be a contingent beneficiary after that. Another possibility is somebody dies and doesn't create a trust for their disabled child. Instead, just lists them directly in the will. And the will is being settled, and we find out that it's going to mess up the benefits for the disabled individual, and we go into the probate court and ask the court to establish the special needs trust at that point. It would have been more foresight for the parents to create the third-party special needs trust, but they didn't, so at this point, the only option we have is the self-settled special needs trust. Then when that individual dies, instead of the balance going to their siblings, it's going to go to the state, as its interest might appear. Some other examples: direct beneficiary of life insurance. A guardian could create a self-settled special needs trust. And the last bullet point there currently is commonly used with special needs trusts, especially in a pool trust, but that's where I think the ABLE Act is going to become very important. When an individual applies for disability, it takes months and months and months sometimes before they get a finding of disability. But their disability check, their first one, isn't just for the month when they're found eligible. It'll be retroactive back to the date they applied. And so instead of being $1,000, it might be $15,000. And then they're told, if you don't spend it by the end of the month, you're going to have a reduced check or no check the following month, and you'll lose your medical assistance. And they don't want to spend $15,000 in 2 weeks. They want to have a savings account like the rest of us. And so they can park that in a pool trust, and soon, in the next couple of years, they'll be able to park it in the ABLE Act. And that'll be with the Bank of North Dakota in North Dakota, and the Department of Human Services and its vendor in Minnesota. Yes?
Is it possible to have both a special needs trust and an ABLE trust?
The question is, can you have a special needs trust and an ABLE Act? Absolutely. And so let's imagine that I inherited $80,000 from my parents in a third-party special needs trust, and then I got a retroactive Social Security check for $10,000. I'm going to have the third-party special needs trust for the $80,000, and then I'm going to go sign up for the ABLE Act with my $10,000. But the ABLE Act, when I die, whatever's left in that goes to the state, to the extent it paid for medical assistance. So if I've got a $10,000 account and an $80,000 account, and only the $80,000 account will go to my siblings when I die, this one will go to the state. Obviously, I should spend the ABLE account first and deplete that to reduce the state's claim, and then dip into the $80,000. But you could have a third-party special needs trust, a self-settled, and an ABLE account. Yes?
Are the expenditures from the ABLE Act similar to what you can use for a special needs trust?
Question is, are the expenditures from an ABLE Act account, they're the same as a special needs trust? Identical. Just fundamentally, any distribution that's not going to adversely affect the eligibility for any means-tested or asset-tested government benefits. Okay. Yes?
So the only benefit of it is that you don't have to pay for the legal counsel.
Correct. The only benefit of an ABLE Act is that you don't have to pay for legal counsel or pay a trustee. So, but I don't know what the fee will be. And so I'm assuming it'll be less than my fee. That's the whole idea, is to keep the legal costs down. And so the big difference between a third party and a self-settled special needs trust, don't lose sleep over the names, because attorneys, judges, they will interchangeably call them different things. Instead, you look into the guts and the wording in the trust, and you look at whose assets funded the trust, and if there's a claim for medical assistance received when the disabled beneficiary dies, and there's no such requirement for payment for a claim to the state from a third-party trust because the disabled individual's assets were not used. So here's some specifics on what a special needs trust can be used for. Now, the interpretations of how this can be used are going to change over time. And what normally changes it are the POMs. Does anybody know what POMs are? It's a Policy and Operations Manual from the Social Security Administration. And so the Social Security Administration will occasionally issue POMs, and an attorney who does special needs trust should stay on top of that so they can advise their clients and their trustees. For example, one of the POMs that came out most recently is regarding gift cards. It used to be very commonplace that when a trustee of a special needs trust was making distributions, either to an individual who was their own guardian or to the guardian on behalf of an individual, they would purchase a gift card, like a gift card to Best Buy. You know, if somebody likes video games or needs a TV or something like that. Well, the Social Security Administration found out that gift cards can be sold. That they're, for people who get gift cards at Christmas and they don't want them, or the place that they got the gift cards so they don't shop there, you can go online and sell your gift cards to other people who want to buy them. And if it's a $100 gift card, you may sell it for $90, but then at least you got some cash back. And the fact that somebody could get a gift card and turn it into cash, the Social Security Administration said that's not a proper distribution. And so there's little tweaks and little interpretations that you have to stay on top of. And again, that's where you need to think about when you're naming a trustee. Are they going to stay on top of these changes of what it can be used for? Because it's not a static thing. It's always subject to interpretation. And if you pay the wrong thing, it can affect eligibility. The pooled trusts in North Dakota, the current pooled trust is GAPS out of Bismarck. There's also ARC of the Red River Valley. And then there is going to be LSS of Minnesota, currently has a special needs pooled trust in Minnesota, and they plan to have one in North Dakota soon too. And usually it's used when there's no family member to serve as trustee. With pooled trusts, it's handled exactly the same. They've got self-settled special needs pooled trusts and third-party pooled trusts. And it's got the exact same payback provisions. So as I mentioned before, a special needs trust, no matter if it's third-party, self-settled, pooled, can never distribute trust dollars to an individual, or it's going to count as income, and any income you make is going to affect your eligibility for your programs. Instead, the trustee has to either buy things on behalf of an individual or pay the bill directly from the trust. And so if somebody wants a TV at Best Buy or a furniture set at Slumberland, the individual or their guardian would go price it out, find out how much it's going to be with warranty and delivery and Scotch guarding and all the other upsells that they give you. And if it comes with $327.51, then you would call your trustee and say, I need a check to Best Buy for $327.51. And then they would do that, and then you'd be able to go get your TV. That's essentially how it works. And having bills set directly to the trustee to pay. When you're dealing with special needs trusts, you need to make sure that you're working with an attorney that has done these before, and not that they've just written them before, but they've written them and somebody actually retained or obtained eligibility for medical assistance and SSI. Because anybody can draft them, it's whether or not they actually work. And so if you are currently working with a lawyer, feel free to share my materials, because they may not be up on some of the current changes, and feel free to share it with them. The other thing is to make sure that the proper trust funding is done. And this, I'm sad to say, too many attorneys in my estate planning area do not help people well enough. And so if I'm working with a family, say a single mom, and she's got 3 children, 2 are without disability, and her son Bobby is 25 with Down syndrome. And my client has an IRA at work, well, 401k at work, she's got life insurance and accounts and that type of thing. I don't just have her sign the special needs trust, third-party special needs trust for Bobby and a will, but instead I'm going to give her wording so that she can take it to her human resources, she can take it to her funds manager, for plan administrator for her IRA or 401k, that she can bring it to her life insurance agent, so that she doesn't list beneficiary equally to my 3 kids. Instead, it should say 1/3 to the trustee of the Bobby Irrevocable Third-Party Special Needs Trust under agreement dated April 21st, 2016. And then 1/3 to this child and 1/3 to this child. But you don't ever list 1/3 to Bobby. You always have to list 1/3 to the trustee of the trust, okay? And too frequently, lawyers will have you sign paperwork, but they don't give you that wording to change your beneficiaries. And increasingly, a lot of the working population, a lot of our wealth is contained in retirement plans and life insurance that don't go through your will. They go through the beneficiary form that you have with the company. And so make sure that the lawyer gives you those beneficiary designation wording. So the best option when I'm helping a family doing estate planning is that they don't just tuck the special needs trust inside their will, but they actually sign a separate document at the same time creating the special needs trust. So when I first started as a lawyer in '97, and I worked with special needs trust right out of the gate. I had a disabled niece, and so it was always an interest to me. And she was on medical assistance in Minnesota. And so I gained experience in it right away. But what I found was that some individuals that were passing away had signed wills maybe in 1994. They signed a will that left everything equally to their 3 kids, but to their child with a disability, the will had a paragraph about creating a special needs trust. And the lawyer thought, well, that's good. You know, she signed it in 1994, and that'll work when she dies. Well, what happened is Social Security came up with some new rules, medical assistance came up with some new wording they're requiring, and so you signed your will in 1994, and then you died in 1999, and the wording in your 1994 will doesn't work anymore. And so now when you die and your will is opened up, the lawyer looks at it and says, oh my. And now we have to go to court and see if a judge will fix the wording in your trust. Instead, what lawyers who work in this field, including myself, have done is we've changed our practice. So instead of just having a page inside your will that gets opened up when you die, create the special needs trust, we have you actually sign a special needs trust separate from your will when you do your estate planning. So your will says equally to my 3 kids, but for my son Bobby, I signed this 2016 third-party special needs trust. And I went and opened up an account like my lawyer told me to, free checking account for $100, and we got a tax ID number for it. And when we signed it, we reported it to medical assistance and Social Security, so it's in their databases since 2016. And then I signed this will that said 1/3 of everything I have when I die, maybe I die in 2040, goes over to this trust that I signed in 2016. So when I die in 2040 and my will is opened up, it's not a grab bag. Instead, it's going to a grandfathered in 2016 trust that's already been pre-approved by medical assistance and Social Security. And so that way it's not a grab bag. So then the disabled child will retain all government benefits and has the benefit of that third-party special needs trust. When they pass away, there is no payment for medical assistance, and the other children or charities, cousins, nieces, nephews, whoever you want it to go, as the contingent beneficiary will get whatever's left after that child dies rather than the state. So here's an example. A parent of a 30-year-old son with Down syndrome dies, single parent. The will provides the inheritance goes to a pre-existing third-party special needs trust for that 30-year-old share. And the retirement plan, the 401k, the TIA-CREF, the SEP IRA, or whatever it might be, and life insurance beneficiary forms are payable to the trust and not to the son. So then the trust is already created. It has been for years, but it's only ever owned a $100 account. And now all of this other money says pay to the trust, pay to the trust. And it's just a big vessel ready to grab money coming from other places. And so the son's share is funded with the home. He can stay at home, and there's money in there to pay the helpers that help him keep him safe in the home. It can have cash, it can have investments, it can have farmland, it can have mineral rights. A trust can own anything you can. And then the son has the use of the home, distribution of the trust funds for his special needs. And some of you who are smart are thinking, but you said it can't be used for housing. Well, the trust can own a house, but it can't give, and let the beneficiary live in it, but it can't give the beneficiary money for rent. So there's a difference between the two. And then when the house is in the trust, The trust can pay all of the house expenses, the property taxes, the heat, the lights, the garbage, the water, the insurance, all of that. So the home is owned by the trust. The son's taking computer classes, the trustee pays for that, pays for the computer. The trust pays all of the cable bill, internet. Trust buys furniture and clothing for the son. Just as when the parent was alive, was helping out the son, it's like the parent is continuing even after they've passed away to make sure their son is taken care of. When the son passes away, the home and any remaining assets are distributed equally to the siblings, and medical assistance gets no payback. Okay, and here's the alternate example. Parent of a 21-year-old child dies, and either dies with no will, or in error, names the child directly in the will. Because if you die without a will, the state of North Dakota or Minnesota is not going to implement a special needs trust for you. Instead, the intestate or default law, when you die without a will, just says it goes according to your closest family tree. And so whether you have a will or not, if it ends up going to the child directly, we cannot do a third-party special needs trust. We have to do the lesser alternative, which is the self-settled special needs trust. So now the guardian who got appointed after the parent died petitions the court who's probating the will and says, "Court judge, if this 21-year-old gets this inheritance, they're going to lose all of their programs, they're going to lose their SSI. And so the court will order that the self-settled special needs trust be created and the inheritance go into there." And then here the child's grandparents live in Hawaii and Florida, and so the trustee can pay for travel, and the child can't travel alone, so I'll sign up to be the chaperone to go to Hawaii and Florida. But when the child dies, even though he's got siblings, they don't get what's left in this trust. It first has to be offered to the state that paid for medical assistance, and that state will take its share, and then only if there's anything left can it go to siblings. Yes?
Since we're talking about travel, if a special needs trust is set up in the state of North Dakota, and the child at some point moves to another state, what happens then?
Special needs trust law is state specific. So it's just like if you apply for medical assistance in North Dakota and move to Tennessee, does your medical assistance move with you, or do you need to reapply in Tennessee? You have to reapply in Tennessee. Even though they both have federal funding, they treat their programs differently. But I can tell you with 19 years experience that North Dakota has some of the most unique, strict special needs trust wording and treatment in all 50 states, second to Connecticut. And so in my experience, when I've had North Dakota special needs trust beneficiaries move to other states, the trust has always worked. I can't guarantee it will, but that's been my experience. When I've seen individuals move from another state to North Dakota with a special needs trust, it never works. Because North Dakota's language is tighter and more restrictive than other states, so we have to go to court and have that trust fixed. So you can move away, but it's tough to move to. So just as usual, North Dakota is protective of its borders. Yes?
Say you have 3 special needs children and you die while they're still minors. How does that work with the home in a special needs trust? Do you have to have a special trust for each of the 3 kids, and the sale of the home would be split equally?
And so in her example, both parents have died, and there's a home now owned for the 3 special needs kids, and presumably they're not running crazy in the house by themselves, but there's a guardian living there. The house would be owned an undivided 1/3 interest in each trust. And then the guardian would stay there and take care of the kids. And then if the house was later sold, it would be sold from the 3 special needs trusts, and each of the 3 special needs trusts would each get a check for 1/3 of the sales proceeds. And so everything funnels through the trust like a separate little entity. Any other questions? Yes?
What if you own property that generates income? Would it be set up for that income to go into the trust, or would it?
Question is, what if a trust is set up that generates, it has an asset in it that generates income? Very common. Mineral rights, farmland. Somebody's parents pass away and they leave them mineral rights or farmland or is sharing farmland. Rental income is paid to the trustee of the trust. The farm rent would be paid from the tenant to the trustee of the trust. The royalties on the minerals would be paid from the oil company to the trustee of the trust. And then it's deposited into the special needs trust account and then used as the beneficiary needs it. And then it's income taxed to the trust. And the trust does its own income tax return. And then to the extent that income was used to pay for things for the disabled beneficiary, the disabled beneficiary receives what's called a K-1, like a 1099 or a W-2. And the trust doesn't pay income tax for what was passed through. The disabled beneficiary at their tax bracket, which if they've got nominal income will be pretty low, would end up paying the taxes. Another way that income goes into a special needs trust is it's a beneficiary of a traditional IRA or 401k. And every dollar you pull out is income. And so it's very common that income will be inside a special needs trust, income generating assets. Got another question?
So it sounds as though when we do this, we need to make sure we go back and change all of our beneficiary
Absolutely.
wording to go to the trust rather than the
Correct.
individual.
If you pay your lawyer good money to get your will done and a special needs trust done, and then you don't change your beneficiary designations, you just threw all that money away. Because if your will reads one way and your beneficiary form reads a different way, which one wins? Your beneficiary form every time. Because your beneficiary form is a contract between you and your company, and your lawyer, just by having you sign your will, can't overcome your beneficiary form. So it's my routine when I'm working with families that at the first meeting when they decide what they want to do, I give them a note to bring blank change of beneficiary forms on all retirement plans and all IRAs to the next meeting when they sign their will and the special needs trust, and I will help them fill it out to make sure that it gets done because it's so important. Got a question?
Can you set up a special needs trust for somebody who's not yet been certified disabled by Social Security?
Question is, can you set up a special needs trust for somebody who's not been certified yet as disabled by Social Security? Are they under 18 or over?
I guess either. We run into both.
If they're over 18, no. They have to be SMRTed in Minnesota, state medical review team, or have letters from 2 physicians certifying to their lifelong disability, or they have to have a pre-existing determination from the Social Security Administration of disability. When somebody's under 18, if they've had a medical assessment such that they've gained eligibility towards some waiver program, and so the government is determining them disabled and doctors' letters are determining them disabled, I will do a special needs trust on the assumption that that's going to be a disability that's going to continue through age 18. However, sometimes when I'm working with families and maybe they have an 18-month-old who is just starting to show some developmental delay and they're not really sure, there hasn't been a diagnosis, they have no idea at age 18 if this individual is going to be able to have gainful employment or not. That's when it requires some unique drafting because they're doing the will when the child is 18 months old. I have no idea when the parents are going to die and if they're ever going to come see me again, so I need a will that's going to work both ways. And so I'll have what's called a gatekeeper clause that says at the time that the child is inheriting, if they've had a finding of disability, then we're going the special needs trust route. If they haven't, then we're going to go the route of a regular trust, a support trust that's going to be there for college and education and that type of thing. And so that's the one time where I won't do a standalone special needs trust with the will. I'll have it all inside the will because I really can't do the trust yet because there hasn't been a finding of disability.
So if you're looking at somebody who's under the age of 18, I mean, we have people who, do not qualify for SSI because of their parents' income.
Yep.
So you establish a special needs trust when they're under 18, but what happens to that if they don't become certified disabled once they turn 18?
It turns into so the question is, what if they never end up being disabled and they've got a special needs trust set up and we guessed wrong and they ended up being much better off than anybody thought? Then that trust doesn't just go to the state or anything. It just turns into a support trust and can be used for their needs until it's depleted. Yeah. So it's not like it goes in a black hole or anything. All right, yes.
So when we say, when you say eligibility for a disability,
Mhm.
does that mean it has to be recognized through SSI or Medicaid? Or, like I have a teenage grandson who's under 18 and is diagnosed with autism and documented and has school records and all of that.
But it really depends on whether or not you're in Minnesota or North Dakota. Minnesota says it can be through a SMRT, a state medical review team analysis. It can be two like-minded physician letters that say your 15-year-old is disabled, and that would give us the precedent to do a special needs trust or a finding from the Social Security Administration of disability. In North Dakota, there is no list of requirements. Instead, it's the judgment of the attorney. And so, since I practice in both North Dakota and Minnesota, in your instance, I would probably ask for a couple letters from the doctors stating that they expected him to have a disability and meet the requirement at the time that he applies for Social Security. Any other questions before we wrap up? Well, I know this is like a fire hose of information, and this is not Trust 101. This is Trust PhD level. That's why a lot of lawyers do not even work in this field. So thank you for coming and trying to learn a little bit, and hopefully you brought some tidbits home that will be helpful for you. And I'll be around if there's any other questions. Thank you.